After nationwide protests and calls for police reform, the state Senate this week approved a bill that would change things on several fronts under the title of Reform, Shift, Build. The measure includes new limits on the use of force, a new certification process for police officers, and changes in the balance of rights to legal remedies for misconduct. To tell us about the measure is a top member of the Senate leadership from the 2nd Suffolk and Middlesex District, William Brownsberger. Thank you very much for being with us, Senator.
Thanks for having me, Chris.
So one thing that we have heard over and over again for many years is that a large part of the problem with police misconduct actually involves a very small percentage of officers. How does this legislation address that?
Well, the heart of the legislation is a new statewide police officer standards and accreditation committee. And that new committee is empowered to receive civilian complaints directly. And it can farm those out to the departments to investigate, or can investigate them on its own in the case of serious complaints. And our belief is that having a central place that's not dependent on the departmental chain of information will allow us to make sure that civilian complaints are in fact heard, and that if there are a few officers who do have repetitive patterns of complaints or serious complaints, even just one very serious complaint, that those officers can lose their license if that's the right response.
So one of the things I imagine you want in this bill is not just individual officers to do things differently, but really whole police departments, their leadership to do things differently. Can you give me an example of what you'd like to see result from this, at least?
Well, you know, it's interesting. You ask an interesting question. The bill is really framed about oversight of police officers as opposed to police departments. So I'm not sure that there's something that guarantees the transformation of the management of a department in this bill. But what it does do is create a mechanism that problem officers will be picked up. That's really what this does, more so than speak directly to the management of a department. Now, there is a conversation about accreditation and police accreditation. We haven't done a whole lot in this bill to, I say accreditation as in accreditation of a department. We have not bought into a particular framework for doing that in this bill. There is a sort of civilian, when I say civilian, non-official, but with very close to official sponsorship, a police accreditation entity in Massachusetts, but we haven't done anything to strengthen that entity or give it more teeth in this bill.
Well, one thing you change in this bill is the threshold for establishing a civil rights violation if a citizen files a complaint. Explain how that would work.
Okay, well, so interesting. I want to just slightly change those words, right? You said we're going to change the threshold for a civil rights violation. Well, yes and no. The threshold to show that a violation exists remains the same and is foundational in our law, which is that excessive force occurs when an officer applies a force that's unreasonable under the circumstances. And that's to be viewed objectively from the standpoint of the officer with their limited information and recognizing that they have to make second decisions and so forth. So that is the jurisprudence of the Fourth Amendment law under the Constitution, which has been imported into Massachusetts and basically followed in Massachusetts. What we have changed, and so that's something, by the way, that on the one hand gives a lot of protection to citizens, and also gives some protection to officers as well, because it has to be viewed from their circumstances. So we have not changed that. And I think there's this perception that some police officers have been given to have that, now every time they, say hello to somebody on the street, they're going to be subject to a lawsuit. And really the threshold has not changed. What has changed is this doctrine of, what would change if our bill, is signed by the governor, is this doctrine of qualified immunity, which really, on the first, which starts with that fundamental definition of what is unreasonable, and that part has not changed. But the part that's changed is the strange case, the strange case that the court has never seen before, because there is this doctrine that if we never have actually told you you cannot do it, then you are immune. It's been interpreted almost that way. So we're not talking about we're certainly not talking about the run-of-the-mill case. I mean, most of the kinds of police violence or police excessive use of force have been seen by the courts many, many times, too many times. So they're really irrelevant to qualified immunity. And we're not talking about the most severe cases either, because those are also not protected by qualified immunity. What this is about is the oddball case. I'll give you an example, and it's a little bit, you can choose whether you want to report on this, but this is a case in Taunton where a police officer got a warrant for a woman's vagina, which, the courts, when they looked into it, it was ridiculous. They broke into her apartment in the middle of the night, dragged her to the hospital. I mean, she was in bed sleeping. Even if she was a drug dealer who used that as a way to hide the product, that certainly wouldn't be there in the middle of the night. So this was really an intimidation tactic and really an act of violence. But the courts concluded that they threw the case out because they said, well, we never had a case that said you can't do that. That's what's wrong with the law. So things that are truly outrageous and should be, and if any court really reviewed them, would be found to be against the law. They don't make it over the rail because the court says, well, there's nothing specific that prohibits that. So it's a long explanation. It's very confusing, and people have had trouble understanding it. But and it's created a lot of controversy. But that's what it is.
Well, qualified immunity can be an insurmountable barrier for some very legitimate claims against police, but police unions say changing that will open the floodgate to frivolous lawsuits. Is this necessarily a zero-sum game here where a win for the public is a loss for the police?
Well, I hope this is what I'm trying to explain, which is that no, it's completely not about to open the floodgates, because the fundamental protections for officers come from constitutional jurisprudence. Their actions are not to be reviewed, from a 2020 hindsight perspective, sitting in an armchair in the peace of the judge's chambers. No, they're to be reviewed from the standpoint of the officer on the street, making tough decisions, having trouble, seeing exactly what's going on. The courts are entirely cognizant of the challenges that police officers face, and nothing we've done will change that. What will change with this qualified immunity tweak is the way the courts handle the oddball cases, the cases that the courts have never seen before, and like the one I mentioned.
Another feature of this bill that is of interest here in Boston, at least, is what you're going to be doing about stops by police to question people or sometimes search them and getting information about possible racial profiling. So would things change if that were to be approved?
Well, this would create a couple of things. I mean, two things of significance. One is it would create additional record keeping, and record keeping that the public would have a little bit more of a handle on. So when somebody gets stopped, as in detained, not just hello, how you doing, but you can't leave for a little while. Whenever somebody's detained, they should get a receipt that acknowledges that, and sort of like as if they've been stopped in an automobile. Whether they're given, usually when you're stopped in an automobile, if you're not given a ticket, you're given a warning. But anybody who's stopped, and that's an important idea, you've been detained, should get a receipt. That's idea number one. And number two, there should be full record keeping of, we have record keeping of motor vehicle stops, and as part of our cell phone bill, we added race information to that record keeping, but this would add that for, stops on the street, pedestrian stops, if you will.
Do you think there's
and by the way, I'm not sure I said it, I should have, I apologize. It would also explicitly ban racial profiling.
One of the other things that's in this bill is the part called rebuild. What would that mean exactly?
Well, let me be as honest as possible, right? I think we in the category we have this reform, shift, and build is the moniker of the bill, right? The reform thing we do at scale. The changes that we make in the oversight of policing, requiring that for police to have licenses, a central complaint body with its own investigative powers. Those measures, if adopted and implemented, will have a significant impact on policing across the state. We also have the other themes are, I would call, a little bit more in the down payment category. We have shift and build. And so there's a lot of people that believe, and I'm very open to this argument. I think there's a challenge in how you think about making it happen, is that we should be shifting resources from force and punishment to helping and lifting people up. Do we always, when there's a problem on the street, whether it's a mental health problem, a homelessness problem, or even a dispute of some kind, is a police response really merited? In fact, it does, having somebody show up with a gun on their hip, does that escalate things intrinsically? George Floyd, right? It started over a $20 carton of cigarettes. I mean, could that have been handled a completely different way? Never mind the police officer. Did it really make sense to have force show up on that scene at all? And so that's a deep question, and that's one that we have several resource shift ideas in the bill. All of them are, I would call, preliminary. In the build category, we have a new commission, a new African American commission comparable to the new Asian American Commission. We attempt to fund it at a solid level, and so that's I would call that. It's obviously not transformative. Doesn't address racism as a whole. Doesn't lift up the Black population of Massachusetts. But it's a step in the right direction. So I'm just sort of distinguishing the scale that we're achieving our results. I think reform is at full scale, shift and build are at more modest scale.